Morning, Al.
Morning.
I'm going to put my microphone on mute because I have children at home and others, and I don't want to be a distraction. So I'll put it on mute.
And that applies to my team as well, and in fact keep turning cameras off as well, just because it's a bit distracting. Morning, everybody.
Cameras off may be better for most of us anyway, because I think sometimes it can affect the bandwidth and sort of if there's quite a few people in a meeting. But I'm sure the inspector will ask if he needs them on or not.
Be able to post into the chat.
Good morning, Inspector.
Good morning. I'll just wait until 10 o'clock.
I've just put in the chat that my camera's not working at the moment. This has funny moments, so it won't be on, but I assume that's not a problem.
No, that's okay. I'm primarily only going to need to hear from Ms. Hutton and from Mr. Charles. So, okay, it is 10 o'clock. The inquiry is resumed. Good morning, everybody. It looks like I can see most of whom I was expecting, if not everybody.
Just to clarify, Mr. Bale, the Inspector, there's Mr. Robbins is currently on a train. He's on his way to a court hearing, so he is unlikely to be attending. And Miss Denton is unlikely because she's got enforcement assignments, so she wasn't able to rearrange.
Okay, that's fine. And as discussed, this morning we convened to hear closing submissions, so I'll only be hearing from Ms. Hutton and from Mr. Charles in that order, and so everybody else is obviously welcome to be here to listen in. But on that basis, can I ask that other than Ms. Hutton and Mr. Charles, could you turn your cameras off so that we can stay focused on those who are participating? Thank you very much. If the two of you can leave your cameras on throughout, that would be helpful. Just a small matter of housekeeping, Ms. Hutton, you were going to send me a list, or arrange to be sent a list of appearances with names, spellings, and qualifications and the like. If there's a chance.
It's Appendix B to my closing submissions.
Fantastic. Thank you very much. That's helpful. So to your closing submissions then, are you able to upload a copy into this meeting?
So
or get it to me by some means?
Well, it has been sent to PINS, sir. I have been trying this morning. I'm told by my IT team just now that it might be it's only Mr. Harper. If it's Mr. Harper who has the Teams account who can upload it. So what I was going to suggest is I email it round. I wonder if Mr. Harper could just confirm whether that's the case.
I will just. Mr. Harper, do you know why, if there's any reason why Ms. Hutton can't upload comments? Meanwhile, I'll just see if I can track down the case officer at my end.
Otherwise, what I can do is always share my screen, but it's obviously preferable to have it.
It's definitely preferable, just in case I want to write in the margin. Mr. Harper, are you there?
Just now saying yes, I can send it. It flashed on my screen and went, so you might be getting it.
Oh yes, yes, please send it to me and he'll pass it on. Yeah.
Okay.
Okay, so if we just pause for a moment. So it's always
Apologies
slightly.
about this,
That's okay. It's always slightly clunkier virtually.
Yes, I've been watching YouTube videos on how to do this, and still.
Sorry, I thought it would be a straightforward thing. People in this chat outside your organisation, it's possible they have message-related policies that will apply to the chat, it says.
Ms. Hutton, would you like me to send a copy to Mr. Harper PDF?
I've done that. I've done
right,
that, thank you.
And I could have sent it all through had it all sent through the case officer. My thinking was there were so many people in this meeting that might be interested that if we could share it into the meeting, it might be the fairest and the easiest way to do it. Mr. Harper, I don't know if you can confirm whether you've got it.
He's just typing something in the meeting chat at the moment.
Is he? So we can't all have access to that then, because I can't see that he's doing that. So,
Mr. Charles, can I confirm that you've got the closings, which I've just sent through?
Have you sent that by email?
Yes.
Not yet, but I'll keep looking for it.
I think there's a delay in the email. I'm just sending a PDF copy to Mr. Harper, so hopefully he'll get it quicker and can upload it.
Thank you.
I've just sent the PDF to Mr. Harper, so he should hopefully be able to quickly add the PDF copy into the meeting chat.
Okay, thank you. Hopefully we need it there. Presumably, Mr. Carey, are you not able just to do that yourself? It's Mr. Harper who's got sole control of the.
To be honest, I didn't even think about that. Possibly I could.
That's okay. I'm sure we'll be there in a moment. It's helpful to have the chat locked down, because normally in these things I'd say we're not to use the meeting chat at all. It won't be monitored, just in case anybody can write a message. It looks like I can write a message, so that's interesting. But please don't. Please refrain from that. I'm not going to be monitoring the chat or using it for any function other than sharing these documents.
Into my box, I'm going to press print so I can get it.
And just thinking ahead to the appellant's closing submissions, Mr. Charles, once we've heard from Ms. Hutton, I'll take a short adjournment, 10 minutes or so, during which time if you could share your closing submissions with Mr. Harper or Mr. Carey, so he can send it to Mr. Harper, and then hopefully by the time we resume, we will have those in the chat as well.
I should be able to add it in. It's just when you're working from home, it's working on a different sort of network to when you're in the office. So it's all becomes more complicated than it really needs to be. But
I understand.
If you just bear with me for a second, I'm hoping it should be there any second now. I think hopefully the weather is making everything want to go slow, so that's my excuse.
Yes, and I don't know what the climate's like in your offices. The offices I can see look like they're probably nicely air conditioned, so you're probably nice and comfortable. But if it's hot where you are, feel free to lose your jackets and ties, just as per the other day.
Yeah, for some reason it's not letting me drag it into the meeting chat, and I don't really know why, to be honest.
So you need to go on the left side.
I think Mr. Harper's possibly having some network issues as well. I don't know. So yeah, I don't know why it's not letting me drag it in. Bit of a Neanderthal with technology as well, I'm afraid.
Okay. Don't worry.
Yeah, both ways I'm trying. It's not letting me drag it in. So
if you can't drop a PDF in, you might be able to paste the text in, which is what I've been able to do. I haven't sent it yet, but I've just pasted the text in. I've also emailed to you my closing, and when I'm on, I'll email it around to everybody else.
Okay, so Mr. Harper's got the same problem. I'm struggling here to get hold of my case officer in a chat. So what I'm going to do, I would like the hard copy if possible. So I'm just going to pop out of the meeting for a moment. I think, Mr. Charles, you've got closing submissions.
I have got all ready to go, and I've received Victoria's.
Thank you. I'm just going to go to my case officer. I'm going to come out of the chat and give her a call. So if you just bear with me, sorry, I'm going to exit the meeting. Just give me a couple of minutes and I'll be back in.
Mr. Harper, I've just sent it on to you by email as well, the PDF. I really don't know why it's not letting me drag it in. I mean, I can drag the text in, but obviously it's a very, very, very lengthy amount of text to go into a chat box. But if that's the only way to do it, then maybe that's what we're going to have to do. Probably not ideal for anyone trying to read it on the chat.
Don't worry, we'll sort it out.
Mr. Harper may have more luck than I might have.
Okay.
Okay, my case officer is imminently going to email those to me, and then we'll be able to carry on. I don't know, Mr. Carey, whether there's any chance that you can circulate them to the other people who are attending this meeting, or at least to somebody who can distribute them.
I can do that if just I have to.
What I would say, I don't think anybody's disadvantaged if they don't have them in real time, because they can listen as well as read. So we don't need to hold up. But I'm just thinking about in case there's an interest, it might be helpful to have those. But obviously, I won't be inviting any comments upon them.
If I'll try and send them. I'll try and send them in separate emails, so that obviously what I'm pretty wary of is I don't want to give out email addresses and send them in one big round robin for like the neighbours and the parish council.
No, that's understandable.
So I will. If you're, I mean, it's up to you, Inspector. But if you're happy to start, I'll get on with that.
I'm happy to start, and I've just received closing submissions from both parties. So here we go. Opening that document now. I'm going to hit print, but you don't need to wait for my printer to finish churning before you start. Ms. Hutton, it's now on my screen, and you can proceed when you're ready. Thank you. I can't hear you though, because you are muted, so I should just have to read.
Thank you, sir. Start again. So these are the closing submissions on behalf of the council. In brief, the council's case is that the parent planning permission has expired and therefore there's no jurisdiction to grant this application. B, in the event that you, sir, find there is jurisdiction to grant this appeal, then it should be dismissed. The appellant has failed to demonstrate a deliverable and workable drainage proposal which meets relevant policies and standards. And C, sir, in the event you are minded to grant consent subject to a condition requiring the provision of a drainage scheme, then the council suggested alternative conditions. On the 29th of June 2026, the appellant sought to introduce a new drainage scheme before the inquiry. The council highlighted that you, sir, had no jurisdiction to grant such a scheme and that there were a number of other reasons why it could not be considered at the inquiry. At the inquiry, the appellant sought to revert to one of its previous schemes. However, the 29th of June 2026 technical note was never withdrawn, and therefore this is addressed for completeness in Appendix A to these closing submissions. Appendix B sets out the council's list of appearances at this inquiry. Dealing first with the parent permission and the fact it has expired. Even if implementation works took place on the 5th of June 2025, these were undertaken without discharging the conditions on the planning permission relating to foul water and surface water drainage. The effect of this is that the parent permission has expired and there is no jurisdiction to grant this Section 73 application due to the operation of Section 73(4) of the Town and Country Planning Act 1990. There's no dispute between the parties that these are properly interpreted pre-commencement conditions. Indeed, they are clear that, quote, no development shall take place until full details of the surface water drainage scheme have been submitted and approved in writing, end quote, condition 6. And similarly, condition 7 is worded, quote, before any construction commences on site, end quote, and condition 8 is worded so as to prevent commencement of development approved by the permission prior to full details of the proposed means of foul drainage disposal have been submitted and approved in writing. The conditions are worded differently, but they have the same effect. The planning permission expressly does not approve the commencement of development or implementation prior to the discharge of conditions 6 to 8. This is not an issue between the parties. The issue between the parties is whether the conditions go to the heart of the permission. Section 2.1 of the Council's final submission set out an overview of its case and whether the relevant conditions go to the heart of the permission. They're adopted and not repeated here. The same is true of the legal principles addressed in the statement of common ground. However, certain points are emphasised in response to the appellant's position. By way of introduction, it's necessary to address the importance of pre-commencement conditions in the planning system. They're applied to give complete assurance that a permission cannot be implemented unless certain details are approved. If those details are not approved within the relevant implementation period, then the permission will expire. This provides absolute assurance that no development will take place without the relevant matter being approved. Set out further below, the question is not how far can you build, develop, change use before X, Y, and Z would need to be confirmed or installed. Rather, the question is how important the matter is to the acceptability of the scheme. The Council relies on the following factors which individually and cumulatively demonstrate the conditions are true conditions precedent. First, as the Council's confirmed, these conditions are something without which the authority would not be content to permit the development at all. And that's a statement in the case of Meisels. And also repeated at paragraph 7 of the conditions chapter of the PPG. Indeed, that much is obvious. The conditions are detailed and carefully considered. They were very deliberately imposed. They're essential to ensure the proposal will manage surface water and not increase flooding elsewhere, and also to ensure foul water is discharged from the site without causing pollution, particularly in circumstances where the appellant may not be able to connect to the mains. They're necessary to ensure both local and national policies are met. Indeed, sir, you heard evidence from local residents, as well as Mr. Robbins, that the issue of drainage was a very significant one for the committee, and they were only content to grant planning permission for the proposal with the protection of the true conditions precedent. That evidence was not contested by the appellant. On the legal test, that ought to be the end of the matter. Second, the conditions relating to both foul water and surface water drainage solutions for the site go beyond the detail of the matter agreed in principle. In relation to this, it can be noted that the condition does not, as some conditions often do, require the development takes place in general accordance with X, Y, Z outline plan and strategy, which is found to be acceptable. Rather, the conditions leave the final provision of how surface water and foul water is to be addressed at the site as a matter for subsequent approval. On their face, the conditions make clear a whole suite of additional information is required to be approved. This included the information set out at Roman 1 to 8 in Condition 6, and additionally Condition 8 did not approve any particular foul water drainage strategy, but left it to be approved. It's noted the appellant asserted at the inquiry hearing that the original planning application had included a drawing of site and finished floor levels, but when asked what this drawing was, one was never produced. The council has been unable to find a drawing which included the levels of the development. But even if there was a drawing, it doesn't assist the appellant because it wasn't approved by the terms of the parent permission. Final levels will ultimately depend on the drainage design. Third, contrary to the appellant's contention set out in its final comments, it's not correct to state that drainage will only go to the heart of permission if there is a particular issue or concern about whether a satisfactory solution is found. There's no basis for this statement in law, and it's noted that the 2 appeal decisions relied on by the appellant do not support this view. It's addressed further below. The correct legal test is whether the intended function of the condition was to prevent commencements of work before the condition has been fulfilled. If it is something without which the authority would not be content to permit the development at all, it is a condition precedent. Conditions 6 and 8 clearly meet this requirement. In any event, there were clear concerns at the grant of consent that adequate surface water and foul water drainage had not been demonstrated, and this was aired by the committee. For the avoidance of doubt, the fact that Mr. French confirmed at the hearing that the planning permission stage, the LLFA, were content that a solution would likely to be feasible does not take the matter any further. A granting or pre-commencement condition cannot be imposed where there is no realistic prospect of an event occurring or solution being found. Thus, the potential for a feasible solution at the planning permission stage does not assist the appellant. Any pre-commencement granting condition will likely to have a feasible solution. If not, permission would be expected to be refused. Further, the LLFA's clear position was that it did not object subject to the imposition of the relevant pre-commencement conditions. Fourth, the position of the LLFA is highly relevant to this. The LLFA explained in Appendix E of the Council's final comments that its whole approach at the permission stage is based on the presumption that drainage can be properly addressed by a true condition precedent. If planning permissions can be implemented without compliance with such conditions, then this creates a situation where the LLFA will be required to take a different approach at the granted permission stage, i.e. requiring full technical design in circumstances where it will not be able to rely upon the security of pre-commencement conditions to prevent development from being implemented before such an important matter is demonstrated to be workable. This position was made absolutely clear at the inquiry, where Mr. French confirmed that it's only at the discharge of condition stage that the LLFA is able to confirm that the strategy and technical design meet current standards, can be built, and can be effective. As he explained, there's a clear difference between feasibility and designing the scheme through and demonstrating it. Mr. French confirmed that key details were missing at the planning application stage, including levels, construction, and point of discharge. Indeed, in this regard, it's relevant that the workability and acceptability of drainage schemes will depend on the detail. As was stated at the inquiry, details which appear minor, such as the wrong levels, pipework, etc., could mean the whole scheme is unworkable. Fifth, the need for off-site works and consents here also means the conditions must be true conditions precedent. The scheme which the appellant is now seeking through this Section 73 consent, and which the appellant was originally seeking through the discharge of condition application, involves off-site development, including on third-party land. This includes the replacement of the PTP on the appellant's land and the laying of a new surface water drainage pipe across Mr. Hallou's land. Furthermore, it became clear on the site visit that the consent will require additional operational development on another unknown party's land in order to ultimately deliver the outflow to the surface watercourse. These elements indicate a clear deliverability issue with the drainage proposals. The need for consideration of offside matters and works on third-party land was an issue which the Council's Planning Committee was live to at the point of grant of consent, and this has been factored into the wording of the conditions of themselves. Both conditions 6 and 8 require the schemes to be demonstrated to be deliverable, and condition 8 additionally requires evidence demonstrating an agreement in place to allow an outfall to be constructed across third-party land. This is a matter which has to be addressed by a granting condition of true condition precedent. 6, it's relevant that the appellant has not managed to provide an acceptable drainage solution to discharge the relevant condition. The scheme before the inquiry, and that which formed part of the Section 73 application, is discussed further below, where it's absolutely clear that this has not been demonstrated to be acceptable. The LLFA was absolutely clear there's insufficient evidence or information to establish whether it is workable, whether it would meet policy and standards, including those which previously applied when the parent permission was granted, due to a failure to demonstrate that discharge would be restricted to greenfield runoff rates. As Mr. French put it when asked by the inspector whether the Section 73 application could have acceptably discharged the condition, he said, it doesn't demonstrate that the design meets policy and standards without full calculations and design justification. The LLFA simply isn't able to say whether or not there are defects. Mr. Charles characterised this as being on a journey. Mr. French said that was fair, but the proof is in the pudding of the technical design. He couldn't confirm that it would be able to be worked out. It needs to be proven and evidenced. Mr. French confirmed that he'd raised these issues in his consultation response on the discharge of conditions application. This was not disputed. Further, condition 6 actually makes clear the details which are required. The Environment Agency has also raised very significant concerns with regards to the proposal, which includes the principle of foul water drainage other than into a public sewer, and also the capacity and type of foul drainage infrastructure. These are addressed further below. It's further relevant that in its 29th of June 2026 technical note, the appellant sought to abandon its original proposal, stated all documents relating to it had been superseded, and provided a new design, which included a substantial drainage basin off-site. And the day before the inquiry, the appellant circulated even further options to address drainage at the site, ID 3. None of these are reviewed by the council and were discussed at the inquiry. What this demonstrates is that even the appellant acknowledges there's very clear uncertainty.
Sorry to interrupt, Ms. Sutton. I think ID 3, I think it was ID 1, wasn't it? Was the first. The menu of options. ID, because we were slightly out of sequence because I asked some questions before opening.
Yeah, apologies, ID 1.
So I had it as ID. I mean, I think we know what we're talking about, but it was that the menu of options that we had, I think is what you're referring to. Okay.
Thank you, sir.
Thank you.
ID 1. What this demonstrates is that even the appellant acknowledges that there's very clear uncertainty as to what any final drainage solution might look like at the appeal site. This is not the simple approval of a design which has been accepted in principle, nor is there the simple reuse of an existing system with some tweaks. 7th, the appellant is incorrect to argue that greenfield development is potentially more sensitive and uncertain as to whether a solution can be found. But this does not apply to the appeal site because it argues that proposals are a reuse of the existing drainage scheme because of reduced flow arising from the change of use in the nursing home. The overall effect is no net increase, take each in turn. This is not simply a reuse of the existing drainage scheme. As Mr. French put it, this is not a light refresh, it's major development. First, the proposal includes 9 new dwelling houses. All of this entirely new development requires drainage infrastructure. Show 2 just a change of use, see below. Second, it's clear from the plans which have been provided that substantial new infrastructure is required across the entirety of the site. Taking Plan 1001, and together with the information understood on the site visit, it appears that there is one pipe currently on site delivering both surface and foul water from the care home. None of the rest of the substantial additional infrastructure exists. It includes additional pipework, permeable paving, chambers, etc. It's clear from the plans that the infrastructure is also required off-site, including the replacement of the PTP. Furthermore, it became clear at the hearing that the appellant's proposal would require an entirely new off-site pipe to connect surface water out of the site and into the pond, and that this crossed third-party land. Further, at the hearing, the appellant's consultant confirmed a permit would only be granted by the Environment Agency for foul water drainage if the eventual discharge was into a watercourse via perforated pipe. Clear on-site visit, the existing pipe would need to be extended, even if the relevant area did qualify as a watercourse. This would require planning permission, and this sits on another person's land. Thus, it's categorically incorrect for the appellant to characterise its proposals as a slight amendment to existing drainage of the care home building. Mr. French was correct to characterise this as major development. With regards to foul water flows, the position is far from clear. The first point is that the question relating to whether the condition is a true condition precedent concerns the intention of the decision maker at the time the condition was imposed. The evidence as to reduced surface water flows from its now proposed scheme was produced in September 2025. So this evidence was not before the committee, and there's no evidence that the committee were content that foul water drainage proposals would be acceptable because the proposal would result in reduced flows. That's a wholly new point from the appellant. Furthermore, the evidence before this inquiry is in fact not clear. The appellant has introduced conflicting calculations to the inquiry. One of these shows the foul water flows to be double that of the care home. The appellant's consultant was unable to explain why the calculations differed. The Environment Agency was consulted on all the Section 73 documentation, including the 9th of September 2025 letter, and its response is clear that the existing infrastructure is not sufficiently sized for the proposed development. Even if it is correct that the appellant's scheme is now presenting would, if it worked, which has not been demonstrated, provide betterment or reduce flows, and this is not relevant to the condition precedent issue. This is a point which is only potentially relevant to the merits of the scheme now put forward in 2026, although see below for what policy actually requires and the existence of a fallback. It is not a point which goes to whether the provision of adequate drainage was sufficiently important at the time of the grant of consent so as to be reckoned to be a true condition precedent. In any event, it remains the case that the appellant's proposal is not simply to put reduced or the same flows into existing pipes. There is significant additional pipe work which requires approval, and also the upgrade to the existing PPTP. Not only is a slight refresh not the proposal now, it has never been the proposal. Rather, the drainage conditions were imposed to ensure the approval of a comprehensive scheme for the entirety of the proposal prior to commencement. 8th, the ultimate levels for the new homes and external infrastructure on sites will depend upon the drainage scheme. The final drainage scheme doesn't simply go to the issue of drainage, it also goes to the appearance of the site above ground. Strangely, at the inquiry, Mr. Charles asserted the levels will remain as existing on site. There's no evidence of that before the inquiry. The appellant's own plan, which it relies on under the Section 73 application and also under the Discharge of Conditions application, expressly states it is subject to a final levels design. See the box in the top right corner. Drainage also goes to the materials used for hard landscaping. As highlighted in the inquiry, the drainage design now proposed conflicts with the hard landscaping proposals which have already been approved by the Council. This is highly relevant. Understandably, landscaping, both soft and hard, is a pre-commencement condition in relation to this site situation in the national landscape, say a true pre-commencement condition. This is strongly supported by the fact that, this strongly supports the fact that drainage must also be a pre-commencement condition, as the details must tie in together. Ultimately, the drainage scheme has wider implications than simply whether or not the site will be acceptably drained. 9th, the Council's position is strongly supported by the relevant appeal decisions. This is addressed in more detail in paragraphs 2.1.10 to 14 of the Council's final comments. In a short summary, Mount View. This related to a single bungalow, and there the inspector held the drainage condition related to below ground works, and it, together with other conditions, were fundamental to the permission which had been approved. The same issues are in play here. Land adjacent to the old school related to a single dwelling, where the inspector noted there was no certainty that the proposal would be able to connect to mains drainage, and foul discharge had the potential to cause pollution if not adequately controlled. The inspector also noted an increase in surface water runoff and an increase in built development had the potential to increase risk of flooding. On that basis, the inspector found it was essential that the means of dealing with foul and surface water be dealt with prior to the works progressing. Here, the foul drainage clearly requires control, and furthermore, significant additional thought form requires surface water drainage proposal in order to address runoff. The motel site at Teddington Hands related to the erection of a motel. In that appeal, the appellant argued the adequate drainage was capable of being provided. The inspector found the condition was truly conditional upon its fulfilment, and that the disposal of foul and surface water were fundamental matters central to the whole development. Further, the extent of works reinforced that view. Again, the same factors apply here. The appellant has relied on 3 appeal decisions. Only one concerns a drainage condition, that's Ashford Grove and Oaklands. In that decision, the inspector stated at paragraph 19 that none of the relevant conditions went to the heart of the permission. No reasoning was given for this exercise of judgment. It would appear to be an outlier with respect to drainage. Notably, the decision does not appear to have any regard to the reasoning of Meisels, which gives further clarity as to what a true condition precedent is. The Council has not been able to identify any other appeal decision where pre-commencement conditions relating to surface water and foul water drainage were not considered to be true conditions precedent. The appellant also relies on Bidford Grange. In that case, the inspector found that a condition which required no development to take place until a schedule of the material, finish and colour had been approved. The inspector found the external materials were of considerable importance to the council, so much that it precluded development commencing until it was approved. The inspector also noted the council refused to discharge the condition previously due to a lack of detail. The inspector therefore found these matters were fundamental to the development permitted. The inspector exercised a similar judgment in relation to hard and soft landscaping. The inspector further found a condition requiring an implementation programme of archaeological work was a true condition precedent, even in circumstances where there was unlikely to be significant archaeological impact. Here, the surface water and foul water drainage conditions are of considerable importance to the council. They're fundamental to ensuring the development does not increase flooding elsewhere, and also that foul water can be drained from the site without causing pollution. Further, here the appellant did apply to discharge the condition, but as set out in the LLFA's comments in Appendix E to the council's final comments, these are inadequate and it lacked fundamental details in order to be properly assessed. Thus, the council's position is supported by the Bidford Grange decision. Finally, the appellant relies on 54 West End. The relevant pre-commencement condition related to the requirement for an approval of materials in a conservation area. The argument being run by the appellant was that the materials had in fact already been approved on the application drawings. The inspector found the application drawings did not provide precise detail, and that in the circumstances of the case, it was reasonable for there to be a condition requiring more detail. Paragraph 14, the inspector found the condition was a condition precedent because it related to a significant matter that was fundamental to the scheme. Again, here, an adequate foul and surface water drainage strategy is a significant matter that is fundamental to the acceptability of the scheme. 10th, during the inquiry, USER asked whether, because part of the development included a change of use of the care home, whether this had any implications for whether conditions are true condition precedent. The answer to this is no. The question to be asked when considering whether a condition goes to the heart of the mission is not how much development could be carried out prior to the details being finally confirmed or constructed. Rather, the question is the importance of the issue to the Commission as a whole. Section 56 of the Town and Country Planning Act makes clear that very minor works can implement a development, i.e. the laying out of a road. Thus, the question cannot be how much development could be undertaken prior to the works which are approved by the relevant condition needing to be built out. If it were, then no conditions would be true condition precedent. It's also the case that the Planning Commission and its conditions would have to be interpreted as a whole. There's never been a proposal on this site that there would be a separate drainage design, which is approved for the care home and one for the rest of the site. It is not a phased permission. Rather, the permission requires the entirety of the surface water and foul water schemes being approved prior to implementation. Further, and in any event, the change of use of the care home has implications for the drainage strategy. The inquiry the appellants consulted indicated that details of where foul water drainage were proposed to exit the building could be provided to the council. The implication being this has not yet been provided. Furthermore, as Mr. Charles stated, the change of use requires works to parking spaces, etc., under which it's proposed to put paving. Simple fact shows that the change of use of the building has implications for the drainage design. And finally, for the avoidance of doubt, there is in fact no evidence for the inquiry that the Commission was implemented through a material change of use at the site. Stenton confirmed the inquiry she did not recall apartments even being laid out internally when she visited the site in September 2025. And the appellant has not provided that evidence and does not claim that to be the case. Overall, it's clear that the conditions relating to both foul and surface water drainage go to the heart of the permission. As such, the parent permission has expired and there is no valid Section 73 application which can be approved. So, turning to the merits of the proposals applied for, dealing first with conditions other than drainage conditions. The Council has confirmed it takes no issue with the details provided in relation to conditions 3, 13, 14, 15 and 18. This is subject to there being no extension of the development area, including a large drainage basin outside the application site. If, notwithstanding the Council's submissions on the above, should be on that which is dealt in Appendix A. If the Section 73 application is to include a new area of development, then there is concern that the submitted details do not cover the new area. This includes the archaeological evaluation, phase 2 contaminated land, ground investigation report, the arboricultural method statement. Dealing then with the drainage conditions. Before going on to discuss the scheme applied for, it's necessary to highlight that if, say, you find the parent permission has been implemented, there is no fallback position, which includes the resumption of the care home use. This is relevant to the appellant's claims of a betterment or reduced load. Second, a Section 73 permission would be a new planning permission granted in June 2026. No reason why the proposed development should not meet relevant policies and drainage standards today. No justification has been given for this at all in the appellant's documentation. Vague references are made at the appeal hearing to standards being flexible. However, the appellant has not provided any reason why a new consent should not be considered against up-to-date standards and guidance. It's principally these standards which the LLFA has applied when considering the acceptability of the proposals. As set out below, even if the previous standards apply, then the proposal remains contrary to them. Third, it's relevant there's no policy justification for the proposals at all from the appellant. Hasn't even attempted to justify its proposals in terms of policy and standards. Fourth, it's in fact clear that the appellant's drainage proposals cannot be granted as a matter of law. One reason for this is because they conflict with the plans already approved under Condition 10 of the consent. The inquiry the council handed in the hard landscaping plan, which has been approved by the council, ID4. This makes clear that surface outside the care home, shaded green, is proposed to be the existing road made good. Further, there's an area in the centre of the site shown to be tarmac. However, the PRO's drainage plan shows these areas permeable paving, with a separate plan, Plan 1002, which shows concrete blocks, crushed stone, geotextile and a membrane. Thus, there's simply no legal basis for granting the plans which the appellant is seeking approval for, as it would lead to a planning permission with conflicting approved plans. Turning to the scheme. The council relies upon the evidence of the LLFA as to the appropriateness of the appellant's drainage scheme originally applied for. The LLFA is a statutory consultee and significant weight should be given to its position. First point to note is that the application scheme contained two conflicting drainage designs and two conflicting sets of calculations. It was only mid-inquiry that the appellant finally confirmed the scheme it was seeking consent for was the updated details it provided, including Plan 1001 and associated plans. Thus, the condition as originally applied for could not lawfully have been granted by the inspector. Further submissions on this point have been made in the council's costs application. The second point is that key information is missing for the LLFA to confirm the design is workable. Points which have been raised by the LLFA include no final levels information. The plan itself states it's subject to a final levels design, but clearly this is fundamental to whether or not the drainage scheme is workable. Design does not include any survey or information as to how the current pipes run or whether they're fit for purpose or in fact in use. Design doesn't demonstrate how surface water will ultimately discharge into the watercourse. Design does not include construction details or any external works design. It's unclear from design what the chambers are, what the pipes are. There is no detail of the flow control device or any blockage protection, and no chamber details. There's no information as to how or whether the design will restrict peak surface water flows to Greenfield runoff rate, which is a feature of the relevant standards both at the time the parent permission was granted and now. Following the site visit, it's worth saying a little more about the outfall to the watercourse. At the hearing, Mr. French was clear that the LLFA would require proof of downstream connectivity to a recognisable watercourse, and there should not be discharge over land. He stated that even if this were the existing situation, it should be rectified by development. Mr. French highlighted that at the planning application stage, there was shown to be a new pipe and head wall being installed to the outfall. However, that had been removed from the proposals. He stated this is possibly because it's in existence and it doesn't need to be replaced. However, this hadn't been evidenced. On the site visit, it became clear there is no pipe and head wall into the watercourse, and the pipe stopped short of the watercourse, and the pipe had previously drained into the bank, causing erosion. Clearly, no reasonable basis for arguing this should be allowed in such a sensitive location. Indeed, this is particularly the case given the circumstances where the inspector finds the parent permission has been implemented. There would be no ability for the appellant to revert to the care home use. The most recent written comments are set out in the note at Appendix E to the appellant's final comments. This explains that in December 2024, the MPPF was revised to read, and this is paragraph 182 of the MPPF, applications which could affect drainage on or around the site should incorporate sustainable drainage systems to control flow rates and reduce volumes of runoff which are proportionate to the nature and scale of the proposal. These should provide multifunctional benefits wherever possible through facilitating improvements in water quality and biodiversity, as well as benefits for amenity. Sustainable drainage systems provided as part of a proposal for major development should take account of advice from the LLFA, have appropriate proposed minimum operational standards, have maintenance arrangements in place to ensure an acceptable standard of operation for the lifetime of development. Minimum operational standards are the national standards for sustainable drainage systems, which published by DEFRA on 19th of June 2025, these standards are in material planning consideration. Even despite the lack of sufficient information and the lack of evidence to demonstrate the scheme is even workable, the LFA has confirmed the proposals, based only on initial assessment, contravene the standards in principle. Again, further details provided in the LFA's comments, but as summarised here. Standard 1, runoff destination. Proposals do not include provision for the collection and reuse of rainwater. 2 designs provide different locations for the relevant connection. Design is not based on a topographic survey and supported by sections and details. Standard 2, interception drainage. No designs and calculations have been provided to demonstrate that interception drainage is achieved by the drainage proposals. Standard 3, management of extreme rainfall. Multiple designs were submitted for approval, and they wrongly used the entire site area to calculate greenfield runoff for the purpose of peak flow restrictions. The proposals therefore exceed greenfield runoff rate. There's no technical design with finished levels and construction details. Standard 5, amenity. No assessment's been provided of a multifunctional design approach. Standard 6, no assessment's been provided on multifunctional design approach. Standard 7, construction, operation and maintenance. There's no survey of the offsite area where the outlet is proposed, and therefore the technical design cannot be checked. Construction details omit key elements such as flow control chamber and device and attenuation storage, and maintenance plan does not include information on key elements such as flow control device. The LLFA raised its initial concerns on the 2nd of June 2026. Noted the appellant has not actually sought to refute any of these points. Director has not disagreed with the fact that its proposals do not meet the requirements of national policy or the relevant standards. Furthermore, the appellant has put forward no case as to why policy or standards should not be met in this case. The LFA has also confirmed that the drainage proposals do not meet the standards which existed prior to the introduction of the 2025 minimum standards. And these are the non-statutory technical standards for sustainable drainage systems, dated 23rd of March 2015. Particularly, Mr. French explained those standards required the development as close as reasonably practicable to the greenfield runoff rate. Furthermore, the concerns over missing information, failure to demonstrate workability of design apply, whichever standards of policy and guidance is applied. The appellant has asserted its proposals represent betterment over existing. Now, this is a test not found in policy or in guidance, and I've made comments above about those issues. As Mr. French explained, the relevant standards require a hierarchy of methods of disposal to be followed. You can reuse and discharge to ground if possible. If that's not possible, of course, and then if not possible, just proposal must achieve greenfield runoff rates. Further, in any event, there is no betterment, because if the permission had been implemented, there is no fallback to the care home use. Overall, the proposals failed to afford with the written ministerial statement of 18th December 2024, paragraph 182 of the NPPF, paragraph 59 of chapter 7 of the PPG, and the relevant drainage standards with regards to surface water drainage. The Environment Agency has raised clear concerns with regards to foul water drainage. The appellant's chosen approach is a new package treatment plant which would drain into a drainage field and then into a reed bed. The PPG is clear that where a proposal is not proposing to connect into the public sewer, then the application will need to be supported by sufficient information to understand the potential implications of the water environment. The EA has raised some concerns about the proposal and whether it complies with current standards. The EA's response explains that connection to the public foul sewer is the preferred option and must be used wherever feasible. If the applicant chooses alternate means, it must be demonstrated that connection to the public foul sewer is not reasonably practical, supported by written confirmation from the sewage undertaker. The appellant's technical note of 29th June 2026 provides just 2 paragraphs in relation to foul water drainage, and this appears to relate to the updated scheme. This explains that in accordance with the general binding rules, a connection to public sewer should be sought if there's a sewer within 30 metres multiplied by the number of dwellings on site. The appellant then alleges the site is more than the relevant distance, which would be 510 metres. However, that's not correct, because the appellant has chosen a circuitous route via the road. However, there's no reason why the foul water drainage solution should be sited next to the road. It's therefore clear that the distance is well below 510 metres. No response was provided to this by the appellant. As such, on the appellant's own evidence, it would appear that it has not met the EA's own requirements. The EA does require the appellant to discharge the sewerage network, and the scheme will need to accommodate the necessary infrastructure, including any pump. This is therefore an issue which needs to be confirmed now, at the point when plans are confirmed. Further, the appellant's 29th of June 2026 assessment states that Southern Water has recommended the use of an on-site package treatment plant. However, that's not correct when one considers what Southern Water actually said. The email provided simply states that it may be financially beneficial for the project to consider using or upgrading any PTP you have on site rather than connecting to the public foul sewer. It's therefore entirely unclear whether the appellant would be able to receive a permit for the proposals. Indeed, the original permit was withdrawn in 2021, and therefore whether they are at all workable. The EA has also raised concerns over the fact that existing infrastructure would not be appropriately sized for the proposed development. Projecting evidence over foul flows have been addressed above. It's therefore clear to the EA that additional infrastructure is required. Indeed, even the appellant appears to accept this because it's proposing to replace the existing PGB. The EA has gone on to state that if the appellant is not to discharge into the sewer, then in order to meet current standards, a compliant drainage field would be required within the site and safeguarded for development. The appellant sought to explain the inquiry this wouldn't be required. Where the appellant was discharging to an existing watercourse, then there would need to be a pipe which has a perforated section over a 10-metre distance prior to the watercourse. If this is correct, and it's noted that there's not any written assessment of this before the inquiry, it's relevant that on site it was observed that if this is to be achieved, there would need to be additional pipe work, even if the relevant area were to be considered a watercourse, which is disputed by local residents. Those additional works would have to occur over third-party land, and it's currently unclear whose land. Finally, the management and maintenance plan is evidently deficient. As Mr. French explained, it does not cover the whole system, which includes the reed bed and the offsite pipe work. He stated he would never recommend discharging a maintenance and management plan condition until full drainage design is proposed, because it must include the final approved plans. Explained he didn't say a lot on the management plan as written response because there was so much wrong with the Condition 6 proposals. Mr. Charles seemed to accept there would need to be a management and maintenance plan for offsite works, and this could be worked out. This simply underscores the problem with the design. Overall, the drainage proposals breach local plan policies CS2 and WCS 14. CS2 provides that planning applications be permitted only where adequate provision is made for surface and foul water drainage to meet local authority standards, taking into account the adequacy or otherwise of existing systems that feed, to avoid increasing the risk of flooding by surcharging mains or increasing surface water runoff to watercourses. The provision of inadequate surface water and foul drainage plans represents a clear breach of this policy. As the provision of surface and foul water drainage is fundamental to the acceptability of the proposal, it's considered that this is a breach of policy sufficient to represent a breach of the development plan as a whole. As noted, the appellant does not argue that the appeal should be allowed even in circumstances where the drainage proposals are inadequate. Additionally, WCS 14 sets out the presumption of favour of sustainable development. It's considered here the proposals are not in accord with the development plan. Further, it's considered the adverse impacts of allowing this appeal would significantly and demonstrably outweigh the benefits. With regards to this test, the Council makes the following comments. In circumstances where the Council cannot demonstrate a 5-year housing land supply of housing land, the provision of housing attracts substantial weight. The appeal scheme will bring other developments, including economic and social benefits, but the harm of bringing forward inadequate sustainable drainage and foul drainage provision is substantial and weighty, particularly in circumstances where the appellant has provided no good reason why its scheme should not comply with policy and guidance. On that basis, the Council considers the harms would significantly and demonstrably outweigh the benefits of the proposal. Overall,
Ms. Hutton, sorry to interrupt you.
Yeah.
Was there a discussion about the benefits of the scheme and land supply and the like before the inquiry?
It's dealt with in our final comments, because obviously if it's a planning application, you need to consider the development plan, something that was addressed in writing by the Council. It's not been addressed at all by the appellant, open for them to do so.
Thank you.
So overall, there's a breach of the development plan. Further material considerations do not indicate the permission should be granted. Rather, the terms the NPPF, PPG, and sustainable drainage standards indicate the permission should be refused, including when the tilted balance is applied. As such, the Council respectfully requests that even if the inspector was to if you were to judge conditions not to be true condition precedents, the appeal would be dismissed. Turning so to option 4, the appellant has argued that another option open to you so as to impose a condition requiring further approval of drainage details prior to development above slab level. The Council's primary position is the appeal should be dismissed. The appellant's drainage schemes have not demonstrated the existence of a feasible or deliverable drainage design which meets up-to-date policy and standards, or indeed previous standards. Further, there's no good reason why permission granted in 2026 should not meet up-to-date policy and standards. The only design which the appellants put forward in an attempt to meet those standards is that set out in its 29th of June 2026 technical note. This involves significant off-site development in the form of a large drainage basin. The Council's position on why this cannot lawfully be considered under Section 73 is set out in Appendix A. However, the short point is that on its own evidence, there will need to be a substantial amendment to the development area in order for up-to-date standards to be met by the proposal. As such, the proper approach would be to refuse the application, but then be open to the appellant to submit a fresh application with a revised development area and drainage strategy, having properly assessed its impacts. So just add there a signpost back to my comments on the problem of the need for third-party land, and that being a matter which has to be addressed by grampian condition and true pre-commencement condition. But of course, in option 4, you're against me on issue 1, as it were. So, Sarah, if you are nonetheless minded to grant the appeal, then the Council's comments on the appropriate conditions are follows. First, given the centrality of surface water and foul water drainage to be acceptable as a proposal, Council would request that instead an enforcement style condition be imposed, which would read, and so I'm not going to read the whole of this, I'll just give the flavour of it. So it starts with, there shall be no further works, construction or development pursuant to this permission until a comprehensive surface and foul water drainage scheme, including provisions for management, maintenance and verification, have been approved. If any one of the requirements set out in Romans 1 to 3 below is not met, any use or occupation of the development hereby permitted shall be ceased within 30 days of the date of the failure, and within 6 months of the date of the failure, all development carried out pursuant to this permission shall be removed, and the land be restored to its condition immediately before the development took place. And then what the condition proposes is a 6-month period to submit the strategy. It sets out exactly what the surface water drainage, the management maintenance, verification, and the foul drainage should require. Then the Roman 2 is if within 18 months of the date of decision, the planning authority has refused to approve the comprehensive drainage scheme, they'll give a decision, but then an appeal has to be made. And if appeal is made, the decision essentially has to be in the appellant's favour. But if any one of those 1, 2, or 3 are not met, then essentially the permission falls away. So it's an enforcement style condition. So I don't think I'm going to read out the rest of it because it's fairly standard and it's based upon conditions 6, 7, and 8 that currently exist. In the alternative, and you consider that the council says that the appellant's condition is not adequate, and the council suggests the following condition. So a non-enforcement condition would open with, there shall be no further works, construction or development pursuant to this permission until a comprehensive surface water and foul drainage scheme, including provisions for management, maintenance and verification, have been submitted to and approved in writing by the local planning authority. And then the condition sets out the various requirements, again based upon the requirements currently in 6, 7 and 8. And then turning to paragraph 81 of my closings. So in the event that you consider further development should be permitted to be carried out prior to the approval of drainage, then the council considers the appropriate trigger should not simply be slab level. It would suggest the following trigger instead, which could be replace the first paragraph in the condition above. And that would be, no work shall take place above the finished slab level of any building hereby permitted, or external paving or below ground drainage infrastructure commenced until a comprehensive surface water and foul drainage scheme, including provisions for management, maintenance and verification, have been submitted and approved in writing, and then it defines slab level. So the council has drafted this in order to try and assist you. However, the council's concern remains that the slab level trigger would permit foundations, floor slab, or other below ground works to be completed before the surface and foul drainage arrangements have been approved. Those works may themselves determine or constrain the location, alignment, depth and invert levels of drainage pipework, attenuation structures, outfalls and connections. They could therefore prejudice the ability to secure an acceptable drainage scheme or require previously completed works to be altered. The council therefore considers the proposal should properly be required before any further development, at the very least before any below ground drainage foundation or slab works are undertaken. So in conclusion, there is no extant permission. The issues of surface water and foul water drainage go to the heart of the commission's case. Failure to implement the commission without approval of those details means the parent permission has expired. Alternatively, the Section 73 application should be dismissed. The appellant's proposals lack the necessary evidence for them to be properly assessed. The information remains missing. So what I've done is I've dealt with the 29th of June scheme in Appendix A. I don't know whether you want to read me to read it out. I don't look for completeness. I mean, the 29th of June scheme actually wasn't discussed at the inquiry, but because it was part of the note which had been accepted by you, I've provided submissions on it. So I'm happy to either just leave those in writing or summarise them or read them out.
Okay. So this response to the 29th of June scheme, as you say, we didn't have a major discussion about it or a significant discussion about it. How can I be sure that new evidence creeping in here?
So it's not.
If it's
new,
the
I mean, it's not
council's
new
response
evidence.
to something.
Yeah, it's really that it would be unlawful for you to grant it. So this has actually been provided to the appellant before as part of the costs application. And it's just included here for why you would essentially have no jurisdiction to grant that consent. And it would be unlawful to entertain it in any event. So, I mean, it's here for complete. Yes, it depends really if
Sure.
there's any prospect of it being relied upon.
Mr. Charles, are you happy for me to accept this as read?
Yeah, I am, sir. The point about the 29th of June technical note is it does slightly do two things. It explains the original scheme and the sequence of the evolution and what was in the original scheme, and then it in addition proposes the off-site basin as an optional add-on. It's not superseding the original scheme, but it does help to explain the original scheme, but it doesn't actually change the original scheme. You remember, sir, when we discussed the conditions that you would impose if you were going to approve the original scheme, we think that actually you don't need to include the technical note in that approval because it's an explanation of the original scheme, not actually the original scheme itself. So I think I'm content for those comments to be included. It mischaracterises what the June technical note actually does, but you've got it, sir, and you'll form your own view about what it does. But our profiling of it is that it isn't changing or superseding the original scheme. It explains it, but you don't need the explanation to decide that it was okay, and adds in the potential for the large basin. We talked about that at the inquiry.
Okay, thank you. Then I'll just take that as read, Sutton.
So you have that, and then you have Appendix B, which is our list of appearances.
Thank you very much. That's helpful. Thank you. I propose just to take a 5-minute comfort break, if we want, just to because we might run over we will certainly run over an hour and a half mark. So I'll just give us a little break now. Actually, let's just say 10 minutes until 10 minutes past 11, and then we'll resume at that point and hear from Mr. Charles. So until then, the inquiry's adjourned. Thank you. wait for Ms Hutton to turn her camera back on. Thank you. I'm glad I took the full 10 minutes. In that time, my printer ran out of paper and then ran out of ink in the space of trying to print Mr. Charles's relatively short document. So, but I have it now. So I'm ready when you are, Mr. Charles, for your closing submissions.
Good, thank you, sir. And I've posted the text in the chat, and I've emailed round to everybody a PDF of it as well.
Thank you. On that, I'll just say I noticed that there are quite a few things in the chat. I won't be looking at any of that at all. So just to put a marker that I'm not sure what's in there, and I'm not looking at it. So
that's fine.
When you're ready, Mr. Charles.
Can I just, sorry, Mr. Charles, I'll just say that the chat was nothing evidential wise. It was just a couple of things about can something be sent, but I have put a message in there to say if they want anything, they can email me, like the residents of the parish council, rather than using the chat function, because I know you prefer to use that.
Yeah, thank you, Mr. Carey. I thought that's probably what it was, but I just wanted to cover the off chance that someone had said something that they thought I might look at, and I'm not going to. Okay.
I have spotted the clerk of the parish council wanted a copy of the closing, so I've added them to my circulation.
Fine.
So my first comment relates to your printing issues. I do just want to be very clear. I don't tend to write extraordinarily long closing submissions, and we've had a good hour from the council. I just want to make clear that just because I don't address every single issue in closing submissions, silence ought not to be taken as acquiescence, and I have in my closing submission, sir, to assist you focused on the key issues.
Thank you. Noted.
Certain issues I don't address, for instance, the point just suggested by council to the council that the floor levels of the buildings would need to be adjusted to suit the drainage scheme. In my, that's a nonsense point, because as you can see on site, the floor levels of the buildings are going to be where they are, and the drainage will, be adjusted to suit it. The site is on a slope. I just think that's a stupid point, and I don't address that. And please don't mistake the length of submissions as to the strength of the respective cases. So these closing submissions are made by myself, Sebastian Charles, on behalf of Maxo Homes. As explained in opening, there are 4 simple matters to be resolved at this appeal. Did works adequate to implement the permission take place on the 5th of June 2025? This has been accepted by the council, and the evidence presented by the appellant not controverted by anyone, including not by the parish council or neighbours. The parish council neighbours did query the date on the SIL commencement notice, which they had seen dated 6th of June. Mr. Murray explained that he had submitted a SIL commencement notice with a commencement date of 5th of June, but this was required to be changed by the council to the 6th of June, the date it was sent in, as it cannot be dated retrospectively. In our submission, this does not controvert the appellant's evidence at all. We also spent some time discussing the internal works to the nursing home building, a wall that was demolished, and the roof works to the lodge, and these were reviewed on site. The appellant is content to leave these additional elements to the inspector on the basis that they sit behind the main evidence of implementation by way of digging foundations, which is uncontroverted, and will respond to the council submissions about costs in relation to this point separately. Do drainage or any other conditions go to the heart of the permission in this case? The only conditions in dispute relate to foul and surface drainage and maintenance thereof. Counsel for the council mounted a spirited defence of the council's case, purporting to back up the draft cost claim relating to this point. However, the council's legal analysis in fact backed up the appellant's case. The question is a matter for the inspector and is a question of fact, not law. It's a matter for fact-sensitive inquiry in context. The council's case was undermined by the council's own admission that it had not investigated the facts, and at the same time as arguing that drainage went to the heart of the permission, had never gone to the trouble of even gone to the trouble to even visit the existing drainage arrangements. Those have been functioning for many years and have been permitted by an admittedly now lapsed environmental permit without any known issues. Furthermore, there is no dispute as to whether the drainage was going to amount to very substantial betterment, and there was no dispute that at the outline stage there was no in-principle concern. The council pretty much settled the case in the appellant's favour, framing the question as to whether this was a matter of detail of a matter already agreed in principle. This is exactly the situation. The principle that there is an acceptable solution was established at the application stage. It is not the council's case, that there is any prospect of a dead end. It is agreed that the drainage is on a journey, the destination being full agreement. We can disagree about whether the destination has been reached yet or how far we are from it, but the council has not suggested the destination cannot be reached. Drainage is an ordinary matter which stands to be dealt with on every permission, and which would not normally go to the heart of the permission unless there was some particular issue or concern about whether a satisfactory solution could be found. It is understood the council's original concern was misdirected about land ownership rights, but that has now been cleared up. Council for the council submissions appear to revert back to the position it originally adopted, that all conditions go to the heart of the permission. Sorry, that should be all pre-commencement conditions go to the heart of the permission. That is covered in the correspondence with the council at an early stage and discussed again at length in the pre-inquiry meeting, and our submission accepted by the council as there being at least a possibility of there being some pre-commencement conditions that don't go to the heart of the permission, and that hence at least the possibility of a valid appeal. It was disappointing that council to the council sought unannounced and rode back from that. Having established that some conditions don't go to the heart of the permission, it is then submitted that the appellant's sliding scale analysis is entirely correct and appropriate. If some do and some don't, there is a sliding scale, and at some point a tipping point that marks the transition from does to doesn't is reached. It is noted and agreed that there are appeal decisions that go either way on this issue. We've been completely plain about that and indeed put into evidence decisions where the conditions were found to go to the heart of the permission. However, it's not a numbers game. Just because there are 3 decisions on drainage that go one way and 1 that goes the other doesn't mean that 3 outnumber 1. The appellant's case and the council's examples are in order of... The appellant's case is that the council's examples are an order of magnitude more sensitive and uncertain than the appeal scheme was not controverted. The appeal scheme is not greenfield development and is essentially the reuse of the existing drainage scheme that had been serving the nursing home with no issue for many years, with upgrades. The proposed upgrades are simple in principle and amount to betterment. Notwithstanding the current system operates fine, it is improved by separating the foul and surface flows instead of putting both through the PTP and adding attenuation to the surface water flows. Even Mr. French had to concede that there is more flexibility to apply to a scheme that is part change of use and part new build compared with a greenfield site or an all new build brownfield site. The aspiration to meet greenfield runoff rates in all circumstances is noted and can be achieved in this case in any event. Yes, there is a new build development as well as conversion, but because of the reduced flows arising from the change of use in the nursing home, the overall effect is no net increase, in fact a substantial decrease, and this fundamental point, see Appeal Document 1.10, has not been controverted by the council. Having established that pre-commencement conditions don't always go to the heart of the permission and that there must be a sliding scale from those that don't to those that do, the appellant rests on its case that after fact-based inquiry, the drainage condition in this case is right at the end of the not going to the heart of the permission end of the scale, below Ashgrove and the Oaklands, where drainage was also found not to go to the heart of the permission and falling a long way short of the tipping point and the other decisions where drainage was found to go to the heart of the permission on greenfield sites. The appellant stands by its comments that the suggestion that the appellant's position on the heart of the permission is untenable as preposterous. It appears that the council, having got the land ownership rights point wrong, and at that point raised no issue at all about the technical details proposed, it has felt unable to objectively consider the matter in the required fact-sensitive manner, failed to actually look at the site and the existing drainage system that functions fine, take into account the reduced flows and relatively minor upgrades required, and has been looking for issues where in fact there have never been any. The appellant is not suggesting that drainage need never be addressed. It is just a question of how far can the development proceed before council could be put under pressure to agree substandard drainage aids arrangements on the basis it's too late, or the proper arrangement is prejudiced or preempted by works carried out. Clearly, digging trenches for foundations can't prejudice or preempt any drainage solution in this case. The appellant has a lot of sympathy for the parish council and the neighbours wishing to get involved in the planning process, and it was entirely inappropriate that the council should hide documents from them and cause them to need to make an FOI request to find out what was going on. However, the appellant has no sympathy with a party trying to create a ransom where none exists. It is unfortunate the parish council and neighbours did not employ a technical expert to engage with the technical issues and did not appear to appreciate the betterment that was accepted and recognised by the LFFA. In discussion, the level of foul flows was challenged by reference.
Sorry, Mr. Charles, sorry to interrupt you. Can you just signpost from my ease of tying things together, the betterment that was accepted and recognised by the LLFA? Which evidence are you pointing to there?
So Mr. French said very clearly that he accepted there was betterment, but what he said is that's not the test. His view is betterment is not the test. Betterment, you should still apply the standards, and before it could be signed off. It's of course very easy to keep saying more information is needed. Mr. Mercer is confident that sufficient information has been provided, and our submission is that this may now be approved by the inspector, either on the basis that the section 73 is not new development to which the new guidance applies, or in the alternative the guidance excludes express provisions that they are to be applied flexibly. My submission, sir, about this weren't vague, as it's been put by the counsel for the council, and I specifically quoted there may be specific circumstances or constraints, such as the type or size of the development, that mean it is not possible to deliver one or more of the standards. In these circumstances, the opportunity to meet the standards shall be maximised. The appellant's submission is that in the circumstances of this case, the guidance can be applied sufficiently flexibly and doesn't require solutions outside the red line to be worked up in order for the details to be approved. The appellant is only seeking that the inspector apply the standards just a tiny bit more flexibly than the LFA is willing to apply them at this point and approve the details. The LFA's judgment that the appellant is seeking too much flexibility is a very subjective one and is a very fine one in this case. The LFA's final consultation appears to parrot much of the council's case on non-technical issues rather than raise issues of material concern about the substance of what is proposed. I'm grateful to council for council introducing the MPPF. I think that's extremely helpful and makes clear that the inspector is obliged to take into account LFA advice, but is not required to follow it, especially in this situation where it's such a fine judgment and where other material considerations relating to the benefits of the development may be taken into account. And I'm also grateful to council for identifying in the standards the different principles that are to be applied, but it is important, sir, to note which ones are mandatory and which ones have flexibility. It's only principle 1 where the word shall is used, and that's specifically designed to say that's mandatory, and principle 1 we fully comply with, and the other principles use the word should, which expressly is a recommendation that includes flexibility. If the guidance were to be applied in such a way that the development were to be frustrated, forcing a resumption of the prior lawful use using the existing system, this would result in a resumption of greater flows, entirely defeating the purpose of the guidance, and this would be perverse. The Council's counsel made a nonsensical circular point that if the planning permission had been implemented, then it wouldn't be possible to revert back to the original use. The appellant's position is if the planning permission has been implemented, it will be proceeding with the scheme. The inspector entertained discussion on the appellant's other options without expressly determining whether they would be accepted or not. The only reason they were submitted late in the appeal process was because of the council corrupting the consultation process, and the appellant ought not to be disadvantaged by that. The appellant accepts the large basin scheme was produced in a hurry and could be found to require planning permission as it is larger than the existing basin. The small basin does merit consideration. It's very similar to the existing basin, as could be observed on site. In the time available, it was possible to survey the existing basin to prove its technical performance, although its practical functionality in its current condition is not controverted. So instead, a basin that does perform to the appropriate technical standard was designed, and the question for the inspector is whether implementation of that design would involve works that would require planning permission. Similarly, the package treatment plant is described as new, but ought more properly to be described as renewed, and if done in the same location as the current plant would not of itself require planning permission. Both options were supported by the evidence of Mr. Murray. There was no reason that planning permission ought not to be granted for either option. This was not controverted by the council. The council's officer says they didn't know either way, as they'd never been to see that part of the site's drainage system. A small issue with the management and maintenance of the flow control devices and the basins, which are addressed by supplements to the management plan. Thank you. Out of an abundance of caution, a third alternative had been tabled only involving works within the application red line and basins performing to the same level as the small and large basins, but distributed. Just 1 second. Turn that off, thank you. By basins distributed throughout the red line area. This is put forward, at least on the basis, to demonstrate that there are potential options for solutions wholly within the red line, and there is no question of a dead end if the prior options are not accepted. An issue was raised by council for the council about the annotation on the approved hard landscaping plan and whether retained and made good area near the entrance would be permeable or not. As demonstrated on site, the area is already in poor condition, and it may be making good would involve pretty substantial renewal in any event, and the surface could be made permeable in that process. In the alternative, either the guidance could be applied more flexibly, or the drainage scheme amended and recalculated, or the landscaping scheme could be amended. That led to a discussion about a sweeper condition, simply requiring a new scheme to be submitted and approved by a new later trigger than prior to commencement of development. This is an attractive option, although the appellant isn't entirely letting go of option 1 and approval of the original pre-25 guidance scheme entirely. A single condition could sweep up foul and surface water and maintenance thereof, which the appellant supports. It could be prescriptive as to its elements or silent and wide in scope. The appellant can see the pros and cons of either approach and does not object to either, but would object to any condition seeking to oppose a new ransom in favour of the neighbour. There was discussion about whether a time limit needed to be imposed. The appellant does not consider this necessary and has every commercial incentive to get on with the development, and it would be perverse if again a too short time limit was imposed, as it was on the original permission, that in fact causes problems that delay development rather than encouraging it or facilitating it to proceed. The trigger for such a condition was discussed, with the appellant proposing no new build development above slab level or residential occupation. It remains the appellant's case that to allow works to proceed, comprising digging foundations and potentially beyond, does not prejudice or preempt any drainage solution. And Mr. Mercer gave evidence to that effect in relation to the slab and conversion of works. So far as I can tell, the council doesn't oppose the conversion of works being got on with. If the inspector does decide to proceed with the sweeper condition for drainage, then an amendment to draft condition 25 will be needed to delete reference to any drainage plan. So I'll just include that as a note. I think it was written on the top of the draft conditions we submitted as well. A few matters raised in the inquiry room and on the site. In relation to the environmental permit, it is a fact that one was in place for the existing system, and Mr. Mercer's evidence that there was no clear reason for it not to be renewed was not seriously controverted by any technical evidence, but in any event, it is not a matter for planning or the inquiry, as that is subject to its own legal regime with sanctions for non-compliance. It was noted that the EA's comments about the sizing of the PTP suggest it may not have fully understood the reduced foul flows, and that it may also have not fully understood the existing arrangements and the changes now proposed. And although the potential for connection to the distant main sewer had been ruled out on the EA's own rules, further liaison with the EA may be required. In any event, Mr. Mercer explained how they could be resolved in the usual way, and there was no suggestion that any dead end had been reached. And as I say, permitting is not a matter for this inquiry. The various pipes and connections of pre-existing infrastructure were viewed on site and were found to comply with Mr. Mercer's description, with no surprises, for the appellant at least. The council did announce that it wished to take issue with the location of the very end pipe in relation to the bank of the watercourse, but it's not accepted that there was any issue with that, and it had seemingly been accepted by the EA for the prior permit, but in any event, it is not a matter that is relevant to planning. In short, sir, this is a really simple case that should never have wasted inquiry time, and if the council hadn't corrupted the consultation process, need not have done so. The reasonableness of the council's conduct is a matter for costs, submissions which are to be made separately. The council should have conceded the evidence about commencement of work sooner. The council's dogmatic approach to the conditions going to the heart of the permission and suggesting the appellant's case is untenable is not informed by even visiting the site and looking at the existing drainage system being modified for the scheme. The appellant's rationale is fact-based after inquiry, consistent with other decisions, and in its submission. That in this case, conditions about drainage simply do not go to the heart of the permission and are simply detail on principle already agreed. It is important not to be distracted by noise about irrelevant issues relating to land ownership rights and or permitting. The appellant urges the inspector to exercise its judgment and approve the original pre-25 guidance scheme in order that the development can be got and the benefits. Had some discussion about that. These were all set out in the committee report originally approving the scheme, which include meeting housing need, bringing the site to beneficial use, addressing dereliction and achieving very substantial betterment, and the ongoing maintenance of the system should all be taken into account. And indeed, this seems to be a large part of what the parish council and the neighbours are concerned about. It only requires it only applies the guidance to be applied in a tiny bit more flexible. So that only requires the guidance to be applied a tiny bit more flexibly than the LFA is willing to do so at the moment. If the inspector has residual concerns, if you, sir, have residual concerns, then the sweeper condition is an appropriate way to allow matters to proceed, focusing solely on the remaining technical issues to the extent there are, in fact, any that need to be addressed. Thank you.
Thank you, Mr. Charles. Ms. Hutton.
So can I just check one issue? Because obviously you accepted ID1, which was the appellant's options, but what you didn't accept and wasn't before the inquiry were the sort of plans and documents that had come in from the appellant by email relating to those the day before. And the reason I ask you that is because obviously I haven't addressed those options because they're not seriously before you, there weren't even plans. So I hadn't understood those to have been accepted into the inquiry, or indeed to be actually pursued by the appellant. But I just did want to double check that.
Certainly my suggestion was that the appeal needed to be determined on the basis of the information put before that. I will note your comments that we didn't discuss that, and should I need to go there, I will make sure that I address any potential for injustice, if indeed there is any, if I want to rely on those.
Okay, sir.
Thank you. Just a moment. Mr. Charles, do you want to say anything on that point?
No, sir. As I said in my closings, I don't think you made a definitive judgment either way as to whether you wish to take them into account. They are put forward as an absolute minimum to illustrate the range of solutions that are available, which are consistent with our case that no dead end has been reached and that there are options to resolve it. As I say, we rest primarily on option 1, approval of the pre-25 guidance scheme, which is before you, and that's not in doubt. We are not really relying on the large basin scheme because I think we accept there is an argument about that. I think the small basin scheme does merit consideration in the way I explained in closing. It technically shows that the small basin is very similar to the pre-existing, and there's a determination for you to make, sir, as to whether those works, if they were needed to carry out, are likely to need planning permission or not. And our submission is that either they don't, or if they do, that would be likely to be forthcoming.
Thank you. Okay, thank you, everybody. So I, just for the record, have the council's closing submissions listed as inquiry document 5, the appellant's closing submissions as inquiry document 6. I have therefore come to the end of the inquiry. I will not be hearing any more about the merits of the appeal. Just a reminder of our agreement that costs will proceed by way of written representations only, and that I'm expecting the application from both parties to follow the same time period. So your initial applications to be made in full by midday on Friday.
Sir, I thought we'd agreed close of business on Friday, and I was going to just clarify what time close of business actually was.
Well, I did say midday because I thought that would allow, my note says midday anyway,
Okay.
because
the
reason being that that should give us time to cross copy to you, so you've got it ready for you on Monday afternoon, on Monday morning rather, whereas if we wait till close of business Friday, there won't be anybody in my office to
that was going to be my next question.
On.
Yes, that was going to be my next question, whether we're waiting for pins to cross copy or whether we should exchange at midday.
Well, I think this, just in case you don't simultaneously hit the button, I think the safest way is to cross copy in the standard way.
Okay.
So by midday Friday, and then at some point on Friday afternoon, my case officer or one of her colleagues can share those with you, and you'll have them available on Monday to be able to make your responses to those by close of business. Now, that doesn't really matter in my mind what time that is, because I think the cross-copying will happen on Tuesday morning.
But don't we then need first thing on Tuesday for cross-copying, and then close of business on Tuesday for final.
On Tuesday, on the basis that there should be nothing new, so I wouldn't expect you to need very long to review and respond to that.
I'm sorry, but I am completely unavailable all of Tuesday.
Okay.
On a nuclear site, so I don't have any. So apologies about that. I had thought I could sort of do them overnight, but if it's going to be during the day, I'm going to struggle. So I wonder if I could.
Yes.
I've got to then travel back on the Wednesday. I could deliver them close of business on Wednesday for a response, and that would then give me the opportunity to do that.
Okay. I don't want to commit somebody else to having to do any paperwork sort of after 5 o'clock on Monday, and I'm not sure what my feeling is. If we said midday again, then that might be a bit early for you, and probably commit you to some weekend work, and I don't want to do that either. So let's say Wednesday then, and that will apply to you as well, Mr. Charles.
So I've written it down now, midday on Friday, close of business on Monday, and close of business on Wednesday.
Yes.
And close of business is midnight, not 5 p.m.
Yes, it can be. It'll be dealt with by my office in the morning, so that'll be fine.
Good, we're all clear. I think I must have just dozed off when you said midday on Friday.
So that's okay, don't worry. So we'll rather than close of business, we can say end of the day. As long as it's there in the
Monday, end of day Wednesday.
As long as it's there in the inbox in the morning, noting that the case officer has a habit of logging in at around 6 a.m. So aim for the end of the previous day, end of day Wednesday. I'm just making sure I've got the note correctly here. Midday Friday, end of the day Monday, end of the day Wednesday. And I'll just provide a little written note to clarify that, but I think that's all agreed. Yes.
So apologies. The council has been made aware of a resident representation from the landowners where I think you went on the site visit of the outfall pipe. As the raise it because the inquiry is not closed. So yeah, raising concern about that issue. I don't know if that's something that you're prepared to accept representations on or not, or what we go back to them saying. I won't tell you what the representation is, but
no,
they've just been made aware, I think, of the issue. I think following the site visit yesterday.
Okay.
Could I you probably don't want to hear from me, but I took the call, so I'll just tell you what the resident said. He said,
Mr. Moore,
okay.
Please stop. I don't want this, before I make any sort of procedural decision, I don't want to know what they said, because once we get into that can of worms, the evidence is before the inquiry, and so that's why Ms. Hutton was being rather guarded about what they said. Now I can understand why that issue may have arisen when it did, but I think we have to say, given the stage that we've got to, it would be unfair to go there now. So yeah, that decision stands. I'm not going to hear that representation. Thank you. Which takes me nicely to my next point, just as I wrap things up, to say that I'm not going to hear anything more about the cases or the merits of the appeal one way or the other. Does anybody have any outstanding procedural questions before I formally close? No, thank you. That being the case, then, may I thank everybody for their help and their contribution to this inquiry. The inquiry is closed. Thank you.
Thank you, sir.